I beg to make an item with that.
Item?
11.
With content of other German script and answer. Wrong.
10th August.
Documents number 12. Like using something for nearing.
No. You're seeking judgment on behalf of Union of India.
For being. With the consent of the other side, consent has already been taken.
After 19 years of the passing of an order, that has been revalidated by the tribunal. The order has to be, have we stayed the order? If you have stayed the order, we can grant you time. Otherwise, no. Have you stayed? To stay the order. Yes, we have already stayed the order, so you can take your time. As prayed for on behalf of the respondent and agreed to by the counsel for the appellant. Counsel for the appellant.
Yes.
Agreed to by the counsel for the petitioner / Union of India and two others. Let this matter come up for consideration. August 10.
26/8.
May I please, Your Lordship?
You retired which year? You just a minute, Mr. Counsel. Just a- Are you aware of the facts of the case?
No.
Are you aware of the facts of the case?
The notional.
So notional, no. You retired in which year? 2005. And the order passed in 2011. You did not make any efforts. Anyway, we'll see it later. Well,
May I please, Your Lordship?
yes.
Lord, I beg to mention for listing of a matter for question.
No, your turn will come in the last. After all, mentioning is over. 13 adjournment slip has been separated. All right. Early birds.
14/8.
Have a good name.
Your Lordship, with the consent of the other side, I recommend for item for 24.
Yes. As prayed for. But you were mentioning for the state of Assam. For the appellant. As prayed for on behalf of the appellant. And agreed to by the Union Council for the respondents. Let this matter come up for consideration.
8th September. From item number 15 to 23, adjournment request.
15 and 16, madam. And for the respondent. 15 and 15.
But they must be circulated. Or yes,
Interim.
8th September.
interim order continues unless we vacate it, unless we resigned it.
Lordship.
It continues.
Wait, this is a lordship. May I take to mention item number 7 and 18? So here, madam, taken consent from the other side. Then it's implementing VPCA. Can it be taken up after we take one?
It's the same case where you are challenging the policy of starting another outlet by BPCL. What authority you have?
Well, there is a report which I think feasibility report there.
Whatever feasibility report, you're nobody to question. You have to argue this case.
Why not?
You argued today.
Can it be next week then?
Is there any interim order here?
Yes, madam.
What interim order?
Because there is an interim order that status quo is on this.
No.
They are running the petrol pump.
No.
They are
No, they have not even started. That has been questioned. Why? Why was there any status quo doesn't mean anything. You don't have to take away the license of this person. This is something. I don't know how this petition is entertained.
Today, if he is ready, I can argue, madam.
No, he wants time.
Next week then I will go.
Yeah, we can't give a longer time
But next,
as prayed for on behalf of the appellants. Let this matter come up for consideration. Let both the appeals come up for consideration on time immediately after the opening. Sometimes in the last week of July.
I'm between.
30th July.
Adjournment slip. Roll it.
10 September.
Yes.
I beg to mention for listing of a matter for motion bill. So,
What is this matter?
my lord,
What is this matter?
matter is with regard to dismissal of my petition, my lord, whereby I challenge the order
Dismissal of your?
of the petition, my lord, whereby, my lord, I prayed for provincialization of my service,
Provincialization.
provincialization.
When did you file your appeal?
My lord, it was filed on, my lord, 6/6/2026.
When do you want this to be listed?
My lord, day after tomorrow,
Next week.
published.
Sir, the paper listing of a writ appeal number 70/2025, any day this week, preferably on Friday, since there is an urgency, sir.
What is the urgency?
Sir, the government has filed 5 tag matters together, 4 of which were dismissed, but somehow the writ appeal in question got left out.
Oh, next week. Monday, Tuesday. Yes, sir.
Any other request? Item 8 to 10 as first item.
We have kept it next week, madam, for the reason that this bench will not be available for 2 days. Orders. Mr. Balgopal, we'll do the orders first and then we'll start reading. It'll take 2 minutes.
It can take any time.
Item 1 to 5 for orders.
दूसरा वाला आगे दीजिए ये अगर आइए There are 2 IAs which have been filed, 1642 and 1643.
That's the first item. Urgency is really the second to 15.
Just a minute. Let's have both the IAs together.
620.
The numbers are 1642 and 1643 or 1641-42.
I am in my lord 1636 and 37. The second item.
No. We are talking about the IAs, impediment application.
There are 5 matters with similar IAs.
So therefore, we are asking for 2 things. 2 IAs have been filed. I don't know. One for impediment.
One for that.
And the other for direction for proceeding with your EC. That basically decides the entire issue. So therefore, So what is the need? We are inclined to impede Ministry of Environment, Forests and Climate Change.
And
We impede that ministry as through the secretary as respond number 5. Then in the other IA, we issue notice.
I only notice what 19 is coming. In the other matter, the parties are supposed to be impeded. That's why my lord, if you like to just have a look at the chart.
Yes.
The first matter, because it was already a category A case, and there, my lords, the TOR is till next year. There only MOUF is required. In the second to 5th matter, my lord, the urgency is because the terms of reference expired on 14/7/26, 1825. And there, my lord, the TOR were issued by the state.
In these matters, TOR expires
Issued
when?
by the State Impact Assessment Authority. But now, because of an amendment in the notification of 8th of September 25, now the central government is the appraiser.
So otherwise also, the result would be the same, except the dates would be earlier. The dates would be earlier for them to respond.
There is, you're not correct. There is urgency in 225.
Urgency, so we will fix it sometimes
19th of May, 6th, my lord. The lodge. Otherwise, fix the 19th of June.
Oh, we made it to 19.
That is all I require.
All right, or if you're not.
Implement.
Implement in all,
Implement in all.
implement in all. And in fact, we will put every case on 19th. After issuance of notice. Who accepts notice on behalf of? Mr. Goswami, you accept the notice
Malo.
and you respond
Malo.
because if the matter is decided, in fact, the entire appeal gets decided.
Oh, in fact, Malo.
If not,
On 19, the letters are otherwise fixed, Malo. Can it be Malo, some more time? Because 19 is forthcoming, Malo.
19th to 7th.
Sort in.
Our vacation starts for 26 years.
Can it be after reopening, Malo?
Everything will depend upon the final.
We have to pass some order, so that's because once the TOR expires, I won't be eligible. to
Now the
apply.
entering
You will clarify why if we at all allow citizen, then we can clarify everything in the final judgment. That's all.
No, that
You
you're
don't
not
see
sure. Quite see my God.
Because
Because all the work.
if the claim expires, they have to apply a fresh. Then fresh study, they say that all this time, but this. See, there is an interim order passed by division bench sometimes earlier, sometimes in March. It says that no third party
There was
instrument. So if no third party interest, would that be limited to the period of term of reference?
the can't allot what's to it.
Therefore, where
It was a single charge, it was a stay of the revocation order, but your lordship is not. The time is only one process.
Mr. Goswami, I'm asking you something different. Now, the urgency that you are demonstrating is because of the expiry of the terms of reference. If your EC is not clear, then all these years of study and research would go waste. Correct. Now, with the interim order passed by the division bench sometimes in March,
Might not be done.
no third party, would that be limited to the period when the term of reference expires? Suppose, or would it extend beyond?
These might not competent authority, that's why we are increasing the MOU. What they say will do.
What happens?
Right.
Suppose your mining plan has been revoked. You have questioned it on the ground that this revocation can't be done by the IBM, by the regional director or somebody. That
Protected by the saving clause in the amendment. of it.
they have done it because of the Amendment Act of 2021.
They are
They say that
entitled.
you're not entitled. This is the basic issue. Now, a distinction has been carved out, the decision to grant lease and the grant of lease.
Yeah.
Because
Seven
distinction is a very
That's
subtle
the
one.
sole issue, my lord, the heart of the matter.
Correct. So what we want to know today from you, Mr. Goswami, before fixing a day, whether this term of, suppose this term of reference expires.
Right.
For some in 2026, for other in 2027. Then would it entitle the other bidders, other participants, other claimants to give their mining plan to us? Nothing.
No,
So
but-
where is the urgency then?
But I suppose I succeed. Then my right revive. But this TOR process which I have undertaken for last 3 years.
No, but how is it going to end? It will not culminate.
One of the application says the cutoff date is there. Now it is 4 years. Earlier it was 3 years.
No, it was extended for 5 years, no?
That is
3 years, 1 year, and then 1 year.
Hydroelectric and river valley. We are not in that. We are in the normal number. 4 years. So, your lordship may make some observation that protects my interest so far as then it
So that we shall not do without hearing them.
I'm not today seeking. The only thing I'm seeking is short.
It practically hijacks the entire issue.
The lordship will mold the interim order in such a way that doesn't prejudice neither me nor them.
Now, that case you have made out, that how it is beneficial for all, including the state. But then that is looking through a prism of a bidder.
Your
Claimant.
lordship-
We can't sort of,
That level, but your lordship is cut off your lordship is so far.
now we put it on 19th, you'll see.
Lordship. No mining activities be done, my lord. I am.
Correct.
It's only that processing and my work which I have undertaken. Should not, my lord.
See, today you are saying this, tomorrow you will say that now that the mining lease was granted and the EC also has been cleared, therefore it has concretized in your
Your
favor.
lordship will, this government is there, my lord, that we won't undertake any mining. That's a feeding in the pleading.
You will not undertake any mining, that is for sure. Even if you want to, you can't.
Today I can't.
You can't. But the question is that will lean in your favor. We don't want to do it without hearing the
Your lordship will mold the will protect both parties. I leave it to your lordship that your lordship will consider on
No,
that.
but we will also consider why all this graphite rich area would be left untapped. That's another question.
That your lordship is protected in fact that in early.
That protection also is temporary, no, it's entering.
I know.
Question is that we can't only allow Mr. Goswami to explore this. No, we are saying like this because these are mineral rich areas. How many square kilometers have been found? It's because of your study. You're the pioneer. You've done it. Now, if you've done it, it is for the benefit of all.
Flow, if at all your lordship allows
The persons who invented aircraft, they would not have done it only for their travel. So what you've done is for the benefit of the state for others.
Legislature had a saving clause, whether I'm covered by that saving clause of 21.
That's an issue. Mr. Goswami, are we questioning that? No, we are not questioning that. We are saying that this entering stay also would be seen from a different angle. That why stop tapping it now? If the process takes so long for environmental clearance and for any other thing, then why should we stick to? Why should the courts direct the state of Arunachal Pradesh to stick to this term of reference of Mr. Goswami?
Because it is approved by the competent authority, we have to comply with it. This is how it is always because
So
there
this
was
was-
no other operating.
Correct. This was dependent on the acceptance of your mining plan. Mining plan has been revoked. Now, have you been asked to give another mining plan?
What? This TOR is subsequent to the revocation because the learned single judge stayed the mining revocation order. Therefore, the processing took place. The TOR was approved. We are following the terms of reference.
Does it not if we decide anything on this? Our anxiety is that if we decide this interlocutory application, it will be like deciding the entire appeal. Then why don't we decide the entire appeal?
Your lordship, I also consider and propose to your lordship some via media by which the lordship will have it on 16. Let the MOU have their say how my lordship.
Or we can consider, let Mr. Goswami respond to it. We'll see Goswami number 2 respond to it. And then we'll see whether, we'll not give you any preferential
That is
rights. That is for sure.
that is true. That
We
I
don't know.
came on some.
You respond on 19th.
Essentially,
We are concerned with non-tapping of the graphite resources for all this night because it is.
the mix of partner, Krishna Venugopal, I understand it already answered. That your lordship can decide the appeal expeditiously as per your convenience. As the stay has been operating for a while. There is really an issue whether my lord 7-6 communicating a decision.
All right, you respond with respect to implement, we are doing it in all the application. You accept notice and then you respond to this, that why the EC processing should not be done. They're not asking you for completion or for giving you, for you to give any certificate to them or to grant them the mining lease. Correct. Because now once mining plan has been revoked, another mining plan will have to be given, that is, many questions will come.
There's an
All right, so 19th of June. 19th of June.
It's already picked my.
All right, on 19th of June, all these applications.
Your lordship may exercise the extraordinary power to extend that may for the end of justice.
We will do it.
That is the second prayer we have. That is my last proposal.
All right, we'll take it and yes.
Deeply obliged.
All right.
Otherwise notice.
Notice is accepted by Mr. Goswami. All right.
Deeply.
Into that.
Upon manner, the state impact assessment authority, and then it will serve upon it. So far as state is concerned, because that's a state authority.
Yes.
He is there.
Mr. Chandran, you are appearing for the state of Arunachal.
Deeply. Right.
There is some scientific to do on that, which I think. What is the first one? 19th of June, 19th of June, 19th of June. 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 19th of June,
Item 8 to 10.
Yes, Mr. Please.
We briefly touching about those points which my learned friend has not touched.
Yes. Up to you.
Wait,
The scheme has to be conceived by you, it has to be done by you.
that,
Now you tell us what we are, most of our questions have been answered, but then you have to tell us what you have to say.
wait. Well, the first question is, what is this inner line? Inner line is a line conceived by the British as per Nagaland is concerned, where they separated the hilly tribal areas which were in control of the Nagas from the plain areas which were under the control of the British. It was decided at that time that they will not disturb the Nagas, their way of life, their custom, their land rights, etc. They were happy with their own customary practice. This is the question. If you were to see what happened 190 years later, that is in 1963, when Nagaland was formed, we'll see 371A. I feel looking at that, maybe it owes its genesis even to that period. Because whatever was discussed there has been discussed here. As far as the inner line permit is concerned, there are two things that I want to bring to your lordship's notice. We have given a list of compilations to your lordship.
Yes.
Compilation is there. And the first page deals with the BFR. Just to refresh your memory, my lord. The preamble gives the various districts which were applicable at that time. And next page is two. Two talks of power given to the state government to prescribe from time to time and to alter by notification the official gazette a line to be called the inner line in each or any of the above named district. So power is given there. Then, my lord, your lordship may see paragraph 3, that is the prohibition given by inner line, and power 4, kindly see well. State government may from time to time prescribe by notification the official gazette a form of pass for each district and may in such forms fix such restrictions or conditions as the state government may deem fit and may require the payment of such dues and fees for such passes in the state government may deem proper. So this, at that time, all these things were conceived. At that time, we were all districts under the province of Assam. Even neither state of Assam was there, neither state of Nagaland was there. But province of Assam was there. But before the province of Assam came, it was Bengal province. Then it became Assam province. No, my lord. Kindly see page number 161, my competition. My lord, page 161. This is the adaptation laws of amendment order 2019. Actually, 11th of December 2019. I got a copy of the dated order in our reply. I'll come to that. In exercise of the powers conferred by 372 of the Constitution, the powers enabling him in that behalf, the President is pleased to make the following orders. So now that whole thing has now come into the domain of the President of India. And here the order 1 is, of course, adaptation laws. Order 2, I'm coming to the preamble, my lord. In the opening paragraph for districts of all these districts, as notified from time to time, section 1 for district substitute states. So this is just I mentioned earlier also, just for refreshing your lordship's memory. Once the district became state, then everything got into the picture that way. So we were competent to make orders, notifications, to draw the lines, to amend the lines, to withdraw the lines, whatever the government would feel appropriate. Then, my lord, I would straight away take your lordships to the first petition, Kiran Pare, that is PIL 22. Yes. Please. Now in PIL 22, I did raise some technical points, but I'm quite conscious of your lordship's views on various aspects. I'm not going into those aspects. I'm coming straight to the merit. Kindly see the prayer clause at page 22, my lord. May I read for your lord, page 22. Main prayer is issue a writ in the nature of certiorari for setting aside the order dated 20th September 2024 and declared as illegal. Second, my lord, is a writ of mandamus directing the respondents not to restrict free movement of citizens who enter all these places and direct them for free movement. Third one is to furnish a lease deed. To furnish a lease deed. This. Finally, issue a direction that. So basically, we are concerned with this notification, which is at page 59. Lord may turn to page 59. Look, page 59. This notification is issued in terms of section 2 of the BFR and the governor, please do so and so. So this contains at serial number 2, Roman 1 and 2. One set of people are there who are who were residing there prior to 1963. So for these people, exempt from ILP, everybody. Next comes 63 to 79. There also, they're exempt. And this, whatever document they require also is hardly anything. All are given property, patta, any government document, etc. Only those who have come into the picture after 1979, they require IL. So if the challenge is only to this, what is the unconstitutionality in the state going in the exercise of BFR, which has been adapted by Government of India through a presidential order to pass one such order? No, my lord, you kindly see. Straight away, I take your lordships to page 67 of my counter affidavit. My lord, yes. 67. Yeah, beautiful. Maybe I'll start from 66, last paragraph. Article 371A was separately enacted to furnish special constitutional protection to the social practices, customary law, and ownership and control over land and resources of the people of Nagada. adaptation oblique amendment orders, and presidential notification, including SO such and such, dated 11th February 2019, which I just read out to your lordship, have been used to extend and clarify the operation of the 1873 regulation, and ILP regimes are at present administered in the states such as Nagaland, Arunachal Pradesh, Mizoram, and Manipur. The ILP is a public order focused. It regulates entry into designated frontier tribal areas to inter area protect customary land, local institutions, and social practices, and to prevent demographic change that may strain scarce resources and provoke unrest, consequences with a direct bearing on law and order and public security. The continued retention and recent administrative use of this regulation demonstrate a continuing legal basis for the ILP as a proportional statutory measure to safeguard indigenous institutions and public security. Central legislation and rules, including implementation of these notifications, have recognized that the areas governed by the inner line require special handling in the interest of tribal protection and public order. Now, my lord, your lord may kindly turn to page 77. I'm just reading out the relevant paragraph. In the 77 is about the formation of state of Nagaland. You can skip that for a moment. Come straight to para 88, page 88. I start from 88, para 17. The President of India was pleased to make an order, adaptation laws. Wait,
Page 88.
88, my lord. I'm sorry, 83. Small overwriting, sorry. The President of India was pleased to make an order, the Adaptation Laws Amendment Order, by Ministry of Home Affairs notification dated such and such, wherein the state of Nagaland has been included in the preamble. Section 2 empowers the government to prescribe and from time to time do all those things. The notification of 20th September was duly issued by the governor, and that is in supersession of all earlier notifications. Then, my lord, kindly come to page 86. Roman 4. That the notification dated 20th September, laid the rules are deemed fit in order to safeguard the interests of indigenous people within the scope and provision of Regulation 83 and under the ambit of 29(1) of the Constitution. As such, it is not in violation of any fundamental right, including those under Article 14, 15, 19, 1D of the Constitution. The issue strikes at the core of public security and safety as uncontrolled illegal migrants threaten law and order in Nagaland. It's against public interest and directly undermines the constitutional safeguards assured to the people under 371A. Such a situation places the public at grave risk and calls for urgent protection. When it comes to security measures vis-a-vis convenience, security measures are paramount and they cannot be sacrificed at the altar of convenience. Further, petitioner have not come out with any reasonable grievance. With regard to statements in 24, the rules prescribed in the notification does not apply to the indigenous members in respect of all these persons. Addressing some key issues and covers supported here, the government is already taking progressive steps to see no inconvenience is caused to those subjects to the inner line. Now I will just take your lordships to some of the notifications which they have incidentally not placed on record. Kindly see my lord, page 101. My lord, important.
Yes.
Yes. Now, this is a notification dated 14th August 2025. In exercise of powers conferred under Section 4 and in supervision of earlier notifications, Governor of Nagaland is pleased to issue consolidated guidelines and revision of validity period and fee structure. So this is completely I would say, resulted in very lenient terms. If they had a grievance that people come from the border, get in and go, they are called the floating population. The Lordship was to see left side serial number 1 under floating population, Kodima, Pushima, Kuduma, and Newland. The Lordship has got that, my lord.
What exactly is meant by under floating?
Under
But
floating means
shoppers.
those who are moving in and out across the border, like for their daily requirements, passing by. That is, they have given the impression that as though it is some India-Pakistan border, you can't move. It's not like that. They're very liberal. And they've taken care to see people who are just in the neighborhood move about their profession. For them, ILP is not required. They just require some pass, which are given below, my lord. Bank passbook, medical book, school students pass, all these things. Same applies to daily wages. No ILP. Transporters flying within the state when they move and go, no ILP. Then you see, my lord, no, they impose certain fees on it. Now we have to see whether the fees are reasonable. What is taken, they are very modest fee. These fees go basically to the village council. Well, ultimately, it goes to them, about 30% or 40%. Just some maintenance charge, not that you take care of all the things, just a formality. If you were to see this agricultural labor, my lord, this is paid by the person who brings them, not by them. They are given 165 days at the rate of rupees 300.
Yes.
So if we were to see this, the category, etc., it is a very nominal fee. Plus, the requirements are very simple, matter. ID card from banks, passport, ID, ration card, school certificate, all these things. Then students, kindly see serial number 7, my lord, students. Students, my lord.
Will be the person employed them and shall be responsible.
Yes.
As far as students are concerned,
Well, we see agricultural laborers, students.
all very liberal. And whatever is there is very reasonable. Now I come back here, my lord. The point which they have not reached. Kindly see 108.8.
Yes.
One. Those ILB applicants coming from the state of Assam, Karimganj, Haryakandi, Dima, Hasao, Karbi Angalam will be required to produce NRC in addition to documents and above.
This is what was being
I'm coming.
questioned. This is what was being questioned by Mr. Potter.
I'm coming.
Because NRC is not complete.
I'm coming. Because I also thought about it, that if they can't get, then they can't enter. That's the clear brief. It's not like that. If they file an application for NRC and they have a number which they give, and they are awaiting the receipt of this, that is enough. I've got the documents, I placed it on the
But how? I mean, what is the clarification from the government?
Yeah, I'm making the clarification from the side of the government. Today I have received, my statement can be recorded. Today. What? Yeah. There is a term called ARN, that is application registration number. If they provide that with
Application receipt number.
a receipt number, sorry, application receipt number. So that is a proof of the fact that they have applied. So if they give that at that time, they will be entitled to these benefits. But along with the other conditions which have been subscribed.
Yes.
I'll place these sample things which I received from the Home Commissioner today.
What is it?
These are these
Yeah.
applications, etc.
Can we just have a look at it?
Sample of them. 2 copies. Give me a copy.
Then.
So once they submit this application, we are conscious of the fact there is a problem.
We keep this on
Well, these are the statements I am making on instruction, or it can be said I have made that statement before. I stand responsible for it. Then, my lord, you ought to see in all the 3 petitions, there is a definite pattern. Like Dimapur is not part of Nagaland.
No, that argument was ultimately it proceeded in the background.
But I
Now,
was
they were only talking about 1905 and saying that in the year 2024 you realize the importance of it. Then where is the statistical data? Where is the data which tells you that there will be a public? I mean, there will be a security problem.
Right.
That was his argument.
Right.
Now, Dimapur, Kachari Kingdom, and all that, it was not part. That argument was no water.
As far as that is concerned, I also found out from where they got it. I'll come to that later. That's important. Because many of the issues under challenge here were challenged before also. I'll bring it to lots of note. One thing has to be kept in mind, my lord, that we have been declared as a disturbed area. State of knowledge. Where under the Special Provisions Act of SPA, once you're discovered as disturbed area, vast powers are given to maintain public order by the commissioned or non-commissioned officers or warrant officers who have the right to shoot, we can kill also. If they find that in that disturbed area, some person is doing any act in violation of law, subject to only one precaution, that they should give a warning. That's it. So this is the situation as far as Nagaland is concerned. And this is based on the reports given by the central government. As far as security is concerned, we can't measure it like what your lordship said on various other aspects. So it is a disturbed area. There is no doubt about it. And as far as maintaining the security of this place is concerned, it becomes very relevant. I also forgot to mention to your lordships that as far as that 8 is concerned, which I just read out, that is going through all those certain areas of Assam. It's not the whole of Assam. Prohibition is not for whole of Assam. Some are those areas which are on the international border. Others are those where there is large flow of immigrants. These are the things which were there, and I will come to the policy decision of the government in this case. The government conceived of this way back in 2019. And there was a cabinet meeting in which the matter was referred to some committee, etc. And after that, they gave strict instructions to immediately go ahead with this. This was in 2019. Those decisions, my lord, I'm just placing for your lord. I carried on.
Lagi perlu kepion.
The first page, my lord, 15th February, Cabinet discussed the report of the Committee on ILP under the chairmanship of so-and-so and approved the report with the following directions. Extension of ILP to the entire state of Nagaland, including Dimapur. Then entrusting to frame and rules, etc. Home Department should initiate the process of development on the online system of ILP. Next, again, 2019, next page, my lord. 9th December 2019. Agenda number 6, ILP Dimapur. The Cabinet discussed the inner line permit in Dimapur and reiterated the decision of the Cabinet meeting held on 15th February 19 and directed the Home Department to immediately issue notification for extending inner line for covering the entire district of Dimapur by suitably incorporating the provisions of such and such and take action. Then, my lord, the last page, and I should have to explain the gap between 2019 and why it was, they said suddenly it was no. We were under the storm of COVID at that time, 2021, 22. And we were very badly affected. Most of the things did not take place. And whatever was locked down for 2-3 years, they started releasing it in the year 23, 24. That was the only thing. Otherwise, Cabinet had given strict instructions, do it immediately. Now, 2024, my lord, recommendation of the Cabinet Subcommittee report. Cabinet discussed and approved the recommendation of the Cabinet Subcommittee report on implementation of ILP in Dimapur, and the Home Department should immediately implement the recommendation. The Cabinet directed the ILP fees and validity period should be suitably revised. So it is not that suddenly from nowhere they issued this. They had backup, they had discussion, vast discussion. They found a committee. Everything was analyzed.
And anything beyond, you would also argue that anything beyond this is not to be brought in the public domain for secrecy. Beyond this is not required to be disclosed.
Well, that's it. I'm grateful. Then, my lord, there is an affidavit of state of Assam. Since your lordship said that's no more relevant as far as the Dimapur and other things are concerned, they have confirmed there is nothing like that. I'm only saying the thoughtless mind in which they are finding this type of public. That, my lord, in effect, is my brief submission as far as Kiran Para is concerned. One point I would like to point out. Whenever you file PIL, maybe an individual for his own community, if it is in public interest, can be all fine. But he has a mandate to disclose for whose benefit is filing that petition. That's enough. If you were to traverse this particular petition, there is not one word on whose behalf he is filing the petition. That's a mandatory requirement under the High Court rules. I'll point that out. So he just, we don't know for whom he is applying and what he is going to do about it. And even that 2024 notification is challenge. I've asked the question, how are you affected? No grounds have been given, completely mistaken. And it shows how lenient views we have taken and what are steps we have to take, taking into consideration for that. That is my submission for this particular. The Lordship will give me indulgence for 5-6 minutes. I will try to discuss one more point, which will be relevant for all the cases. I had placed on record, my lord, at the very inception, an order of the Supreme Court in 2019, presided by the then Chief Justice, Sri Justice Bench, where the constitutional validity of these regulations were under challenge. When I pointed out that I didn't have the petition before me, I had only the order. We had appeared in that letter. So it was pointed out this is only about regulation, nothing of the latest point. But curiously, I find that even the cabinet decision sometime in February 2019 to impose these restrictions, this was also under challenge in that petition. All the grounds that if this comes, this will happen, it will be a violation of this and violation of that, everything was considered. If your lordships permit me, I can just show your lordship that petition. I'll share a copy with them also, just to understand this. Because one vital aspect is when many of these things have been already pleaded in another petition which has been dismissed by the Supreme Court, at least they have a duty to place on record these facts. That fairness demand, not anything else. I just placed that affidavit, madam. Yeah. I have one copy. Thank you. Your lordship may kindly see, my lord. Running page 6, para 19. My lord, I got that, my lord.
Yes.
Yeah, I'll just read it for your lordship's convenience. In 1978, a law was passed prohibiting everyone except the indigenous inhabitants from acquiring immovable property in the tribal areas, and in pursuance to that notification, these were all declared as indigenous communities who enrolled their names, and others have been left out. Now, this 1978, what we are talking about, that is a matter of challenge in that PL number 67, which he has said that he is not pressing that. But what is important is these are issues which were part of that petition, and they know everything about the petition because the petitioner in this case was a public interest lawyer, and he was the one who also appeared in the subsequent petition, which are current parents. So you can't just put something there, don't divulge it. That is not fair. Next, my lord, I won't just take up 2 points. Kindly see, my lord.
Where is the judgment in this case of the Supreme Court? In limine dismissed.
We appeared, my lord, how exactly they had read the petition and come. They expressed their anger and they said, "We'll dismiss on, they said, we'll withdraw it." No, we are dismissing on merits. And I've given the order, I'll give the order back. Given order. To order. Then, my lord, it is there both in page 9, Roman 6, and page 10, Roman 8. I read page 10. More clear. Whether the impugned cabinet decision of 15 February 2019 is consistent with Article 14, 19, and 21 of the Constitution of India. So they have referred to that. And I just draw your lordships to page 9, para 6, my lord. Whether the object of the impugned decision 15 February to extend the provisions of regulation to Dimapur contemplate to create a monopoly of business, trade, commerce, and other activities only for these indigenous people. So this whole issue was part of a different petition. All these things were there. I'm not reading out lease, area, and all those things. I'm not talking about. I'm only saying that. I'm not saying that because of that, everything could be ignored. No, fairness demand. Something is there, whatever is there, you have duty to discuss. And you file affidavits that nothing else is here or there, and they are aware of it, completely aware. Then, my lord, I don't want to take your lordship's much on this issue. Now, my lord, with your lordship's permission, I come to
And please come to page 20. The prayers also. All right. Prayers also are same.
pardon.
Mr. Rajpal, the prayers also are same there. The prayers are also same there.
Hey,
To direct and declare.
Yes,
the
yeah,
independence
I forgot to read that. Yeah.
Acha, all right, you are in a different case.
I will just inform your lordships about the prayer also. Page 20, madam. Though it was on the constitutional validity of that, he said, direct all citizens.
That is what I was showing.
Yeah.
That is what we.
I'm sorry, I missed it out. To move freely throughout the territory of India and all these things, and further to direct respondents not to extend INT. Very important, not to extend INT. All these things have been pleaded.
Why was it not pointed when the matter was transferred to this High Court?
In fact, what possibly could have happened is they would not have disclosed the fact that they have undergone one dismissal. Naturally, whenever you file, my lord, in Supreme Court,
Yes, anything else, Mr. Palgopal?
As far as this petition is concerned, my lord, the first petition is concerned, this is all as far as. But next I come, my lord, to the second petition, PL number 29.
You're through with this, no?
I think that
22 is over.
Here also, my lord. Kindly come to page 26.
Yes.
I'll again come to declare across, my lord. I go by that.
Mr. Bhattakar, you have to see that. Mr. Palgopal has shown that. That was your major plank of argument. Correct. And you had said that in addition to other documents, NRC would be necessary for people from Kachar and all. They say that only ARN is required. All. Yes.
Basically, we only want to know, not any enmity with any group. Actually, they're, and from which place they are originating. That's the only issue. Nothing else. We are not enemies or anything. And at least this is not enforced in letter and spirit, there's a separate issue. But the fact is, even for the sake of argument, it's quite liberal. There's nothing too hard and fast. Nobody will do that.
Yes.
My lord. Now, if we come to para 26, my lord, they have challenged two orders. One is 20th September issued by the Chief Secretary, and the other is 27th May issued by the Deputy Commissioner. The other, my lord, is the same thing.
Same thing.
To formulate a policy, then to direct to place before the decision-making report, call for the export pending disposal, not to the effect. So I come straight to this, the next year, that is at page 31 of the petition, improved order. Start from 30. They read well. In exercise of the powers conferred by Section 4 of BFR 1973, and in supersession of earlier notifications of even number dated such and such, regulating the prescribed fees for issuance of ILP to non-indigenous persons crossing the inner limit, inner line permit, the state of Nagaland governor is pleased to revise the fee. Basically on revision of fees. Now, my lord, your lordship may come to page 31, the second paragraph. The same thing. Those applicants reporting the state of Assam, all these places, will produce, in addition to it, the NR. My answer is the same way. We are not adversarial. We are all brothers and sisters tribal. We have moved from one place to the other. So, but we need certain paper. That's all. Now I come to the next page, my lord. The next B, page 32, 27th of May 2025. Here they were liberalized the fee structure here. For all these things, hardly anything. But what is relevant is on page 33, my lord, same thing. There are two. Those ISBs coming from the state of Assam, they specified 6-7 places required to produce. So same answer here. So as far as this is concerned, these are the offending portions according to them. I've made my submission on the basis of their record. My lord, may I give turn to my affidavit. As far as my affidavit is concerned, I'm drawing your lordship, lord. To para 12, they're saying it is not meant for the whole state, only for certain.
Page?
Page 187. Para 12, the lordship may mark the page. More particularly, page 189, Roman 4.
This is paragraph 14, which starts from page 188.
Yeah, that's right. That's it, para 14. I'll read it from para 14. It is submitted according to the parent regulation, local extended areas mentioned in the preamble inter area Naga Hill, as mentioned in the preceding paragraph, Dimapur is part. President of India was pleased to pass an adaptation order. Next is the section 2, which I have already covered. Now we come to the third portion of this, that the notification dated 20th September was duly issued by the governor in pursuance of the cabinet decision, and that is in supersession of earlier notifications or even number later sections. Notifications laid the rules as deemed fit in order to safeguard the interests of the indigenous people within the scope of the provisions of 1870 regulation and under the ambit of 29(1). As such, it is not violation of Article 14, 15, 19 of the Constitution. The issue strikes at the core of public security and safety, as uncontrolled illegal immigrants threaten law and order in Nagaland. It is against public interest and directly undermines the constitutional safeguards assured to the people under Article 371A. Such a situation places the public at grave risk and calls for urgent protection. Then it is continuation of that. So then, my lord, may kindly see the last portion I will be reading is page 191, Roman 2. My lord has got one?
Yes.
Yeah. The present ILP regime does not mean to create internal barriers and is not restrictive, but is a mechanism to put in place a robust system for improving the implementation of the ILPL Act sanctioned under VFR. It is humbly submitted. There is no restriction of movement among any legitimate tribe citizens of the nation by implementing ILP. There is ample opportunity to grow and serve that. To further submit, there was extensive deliberation, and upon finding ILP be implemented in Dimapur, Chamapur, etc., notification was issued as provided under this. So this is basically the issue as far as this petition is concerned. Restricted to this. May now go to the next petition.
Next is to that only Assam Land and Revenue Regulation and.
That they don't press.
In fact, as far as all these notifications are issued, given by the statutory power, which is all from
that.
So it was not that we don't have the power. We have the power. We are.
So anybody pressing that petition, Assam Land Revenue? No, it's all right.
Then
Nine.
the third page,
Third petition is what?
67.
67 is basically the challenge to amendment to Nagaland Land Revenue Regulation.
Very well. That amendment.
And indigenous.
I come to that. I come to both.
They have abandoned that challenge.
They don't challenge it now.
They are not pressing it. So
They're not pressing it. Who is the advocate on record here?
Mr. Kumar.
I don't have to.
Mr. Chaudhary, yes, he has said he will not press this. So we don't discuss it unnecessarily. All right. Anything that you have to say, Mr. Bothakar, in the absence of Mr. Chaudhary? You reply yours, if at all you need, you deem it necessary.
I have already submitted my part.
No, does it satisfy? I mean, we are not looking for your satisfaction. We are just asking for our confirmation. Now, this was your major concern. This is
That was our.
your major concern.
No doubt.
Now, otherwise also everybody is required to apply for NRC. Now that application ARN number is good enough. Does that create any impossibility in getting it?
No, so that I don't have, I will have to take.
Correct. And you did
Right
not.
now, I can't make any submission on that. My concern was that you know, in many cases, you know, those people do not have the main India alert. That is what.
But they are bound to apply for it.
And
Otherwise, who knows whether he's a.
and in fact, your lordship, the BIF is concerned, your lordship may kindly
On object.
no object your lordship that is not good. They can always do it for your lordship. May kindly come to page 72 of my petition. Your lord.
Yes.
Your petition is 60?
29,
Yes.
page 72. Start from page 72 last. Your lordship. Clause 3 of the regulation. It shall be lawful for the state government to prescribe and from time to time to alter by notification the line to be called in each of any state of union. Then you know the next two. The state government may by notification the official gazette prohibits citizens of or any class of citizens or any person residing in a passing through such district going from beyond such line without a pass under the hand and seal of the chief executive officer of such district or of such other officer as may authorize to grant such part, and the state government may from time to time.
Correct. So what do you
Now,
want?
Your Lordship, they can do it for a class of citizens, Your Lord. And they can, Your Lordship, they can exempt some certain class of people from that, Your Lord. Our concern regarding this, Your Lordship, has been submitted by me, Your Lordship, that the historical connection that has not been taken into consideration by the authority, Your Lordship. And we cannot remain oblivious of this historical and cultural relations between these group of people, Your Lordship, who have connection with the people living in Dimap.
So in a sense, you say that there should be an exclusion.
Yes, Your Lord.
This-
So far as this is
So
not.
their exclusion or insistence of NRC is so far related to Hailakandi,
No,
Karsar,
not Highland.
Karbi Anglong.
Karbi
Anglong. Your concern is that not all citizens of Karbi Anglong and Dimasa, but this Karbi and Dimasa.
That is not our
That is-
specific prayer, nothing more than that. We are not agitating on behalf of all.
No, but how? How is it going to be carved out?
No, Your Lordship, till date, Your Lordship,
Yeah,
Dimap
correct.
was out of the purview of
No,
this.
but what
regime, Your Lord.
the moment the power is if the source of power is there,
That is,
and the notifications are not unreasonable, they're not asking for something which you cannot procure, and otherwise which is mandatory for you, you have to have an identity of something, some identity card, whether it is ration card, whether it is driving license, whether it is PAN, whether it is whatever. So this NRC you must have, because there are many people in those areas also who can be treated as immigrants. Now, unless you have that ARN number, NRC has not concluded, correct? So is that an impossibility? And why do we have to take the historical background, especially when the source of power is there and the competent government legislature has passed this? And you have seen the cabinet decisions. Beyond that, what statistics can we direct for its disclosure? Now it will defeat the very purpose of implementing all this. Because if everything is laid bare, I don't think it would remain. I mean, these are.
that is not for public consumption, but it is always for.
But the cabinet took a decision. Cabinet has taken a decision, and cabinet has taken emergent measure. They say that immediate is. All right, yes.
That is.
So we concluded. Now just ask Mr. Chaudhary. We have to be doubly sure that he is not pressing that. Huh? All.
Then also in the 16.4 program, which was an arrangement between the government of India and the Naga National Council in 1960, there was a respective agreement, which was a prelude to the formation of the state of Nagaland. The last condition was that we will maintain the BFR in the state of Nagaland. It was agreed by central government.
Mr. Balgopal, we may not go to that.
No, I'm not saying, I'm just saying.
There are many points in 16-point charter which,
That's why I'm not going.
which even you will say has not been followed. So why do it? We are testing the validity, not the procedural. Anyway, ask me. All right, Mr. Balgopal.
I'm good.
Arguments heard. Judgment reserved. Now, we will reassemble after 5-10 minutes. Ask Mr. Chaudhary to be here. We will just ask him and then Mr. Chaudhary, anything in rebuttal?
On merits or on the Supreme Court order?
No, that Supreme Court order is just for our concern. Now, are you pressing that matter where you have questioned the Assam land revenue? You don't.
No.
Correct. Rest, I think you're right.
Only one small point.
Yes.
Now, we will have the constitution for a moment. Yesterday, my friend Mr. Gauhati has asked this point. Please come to Article 19.5 below. But Milord, there is one aspect on that land revenue regulation aspect. Milord, if we go by the content of Chapter 10 of the Assam Land and Revenue Regulation, it's a regulatory. It's not a prohibitory bill. Basically, Milord, a non-tribal cannot acquire or purchase land in a tribal bill. Only to that extent. Nothing beyond that. Now, if by adoption of that, if they have tried to do something more than that, then naturally that will not receive any judicial implementation from the law. On that is my limited submission. Now here, my lord, nothing in subclauses D, E of the state clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing reasonable restriction on the exercise of any right conferred by state subclauses, either in the interest of general public or protection of privacy. So, my lord, if a restraint is to be imposed on enjoyment of 19.1,
Clauses D and E, that is
D and E will not
freely and reside.
only on two grounds can be invoked, that is interest of general public or for protection of interest of scheduled tribe. If a lordship kindly comes to the affidavit filed by the state in item PIL 22 of 25.
They have used the word security.
Law and order and security and immigration.
Yes. Now, please come to page 91.
That is, look at this. Now, we are not trying to make out any distinction. These are known distinctions which have been carved out by way of judgments. Now, public order and law and order are two different things.
Of course.
The expression used here in 1905 is general, in the interest of general public, which includes within it public order also.
No.
It's a larger Venn diagram where it overlaps.
Subject to correction, I don't think there is any case law that in that direction. Maybe Milord, at least we have not been able to lay out.
General
Advantage understand in the
what is the interest of general public? General public is that, these illegal immigrants should not come. They should not.
when it is protective discrimination, it naturally Milord, it cuts out an exception to generally. Let us be very clear about.
Can you completely take away that public
No.
order?
No, the general interest, of course, the general well-being has to be the first and foremost.
The distinctive line between public order and law and order
Yes,
is there.
full concentric.
They are not seeing that statement in the affidavit as public order, as law and order. It's a public order. Public order is the general interest of public. Let's put it this way. Now, case law, precedent or not, but practically this is what happens.
No,
How do you explain public?
But Milord, Supreme Court has taken exception to this.
It is in the context of distinction between public order and law and order with respect to preventive detention.
Yes.
So that is not the question which
I
is
think in Modulima's case, Milord.
many, even Akeroy.
Ekera.
But that distinction is there. We are very conscious of it. We have lived with that distinction and we apply it everywhere. Public order and law and order. Here it is general interest of general public.
Anyway, Milord,
In the interest of general
I
public.
would like to read para 91. Page 91, Roman 4.
This is PIL 29.
No, 22, Milord. That's part of para 20 of the affidavit filed by the state.
Page.
In my copy, it starts at page 90, Milord. The relevant portion which I would like to refer is at page 91. That notification dated so starts the sentence starts with
That's the big one.
The paging is different.
No. This will be, is 88, I think.
86. Sorry.
86.
That is notification dated 29/24. Laid the rules as deemed fit in order to safeguard the interest of indigenous people with the scope of provision of regulation 1873 and under the ambit of Article 29(1) of the Constitution. As such, it is not violation of any fundamental right, including those under Article 14, 15, and 91D. The issue strikes at the core of the public security and safety as uncontrolled illegal immigration threatens law and order in Ireland. Supreme Court has invoked fraternity, Milord, to save Section 6A Constitution bench. The issue strikes at the core of public security and safety as uncontrolled illegal immigration threatens law and order in Ireland. It is against public interest and directly undermines the constitutional safeguards assured to the people under 371A. Such a situation faces public and grave risk and call for early protection. I don't think, Milord, this is the purpose for this 19(5) can be invoked to put restraint on somebody's right of free movement. That is absolutely wrong. If this is the stated stand of the state, with all respect, I submit, Milord, I don't think it can be saved.
All right, we have taken
Yes.
into account
Yes.
your.
Now, Milord, para 21 for a moment. That with regard to the statement made in para 24 of the PI, it is submitted that the rules prescribed in the notification dated does not apply to the indigenous members of the scheduled tribe in respect of the state of Nagaland. Sorry, Nagaland, that is Naga, Kachari, Kuki, Garo, and Mikil. In this regard, state government has subsequently issued a notification dated 18/4/25, addressing some key issues and covers most of the concern. If your lordship to reflect this in the order of the your lordship, but that this does not apply to Kachari, Kuki, Garo, and Mikil. It is the stated stand of the state. And they're referring to a notification, but it does not include all this. It refers to something else.
No, that cookie Garo is referable to the other notification
Of 2025,
IIC,
24.
IIC.
Ah.
So they said they
But-
are
but some-
already notified as scheduled tribe of Nagaland, therefore,
No, I
so
think-
far relating to
I think
IIC.
when it comes to issuance of indigenous certificate, even they are now not eligible. So in that view of the matter, my lord, my humble submission is, lordship would like to reflect this in the lordship's order, because that this is the stated stand of the state government.
Yes.
My lord, if your lordship would kindly come to Article 19(2) for a moment, my lord. Nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law, insofar as such law imposes reasonable restriction on the exercise of the right conferred by state subclause A in the interest of sovereignty and integrity of India, the security of the state, friendly relation with foreign states, public order. So public order is an expression which is expressly included in 19(2) and it is not included in 19(5). For that analogy, with all respect.
Correct. So
cannot
I'll be repeating
cannot
the
be
same.
appropriate.
I will be repeating the same thing. It might sound tautological, but then in the general interest of public,
Yes.
would it not cover public order? The general interest of public is served when? I mean, this is one view which can be espoused. Law and order, public order are two different things. It's a larger genus where law and order forms a smaller
Very
part.
concentric circle.
So public order is in the interest of general public. Can it be doubted? Public order is in the interest of general public, which is the expression used in 19(5).
My humble submission would be, when we speak literally, yes. But when it used in the context of Article 19(2) as distinguished from contradicting from 19(5). Perhaps
19(5) gives a bigger power.
with great respect, my lord. But 19(5) is confined to only two grounds: interest of general public, protection of interest.
Interest of general public is a big circle where all things can be incorporated. Otherwise, what is the interest of general public? You just tell me in yes or no. Literally, of course, you have said. But otherwise, can you conceive of a situation where public order is disturbed? Can it be called in the interest of public, in the interest of general public?
Lord, to understand the
Lord,
constitutional
see,
mandate,
this
is it
assumes it.
permissible to refer to
Correct. Mr. The difficulty here is this. Now we have grown with this idea in our mind that public order and law and order are two different things. So this was basically in the context of, if you recall, A.K. Roy, Madhuri and all that. This on the grounds of public order, there could be no detention. It is public order. Or public order is a bigger concept. And public order will embrace, it will inhere in itself. I mean, the general interest of
I'll
public.
leave it to lordship.
That's
And
the debate is endless. You get into that abyss and you don't come out.
Regarding the judgment, my lord, that Shakal newspaper and the other one is 2023. My letter is already placed. I'll not trouble your lordship again.
All.
Therefore, to sum up my argument is, my lord, I have already asked 3 points. This point I left to be because state in their affidavit has clearly come up with that stand. That's why I thought I was talking.
Correct.
Deeply.
Yes, sir. एक जगह correct कर-
Portable judgment for the screen customer.
Okay, sir. It's pretty. Not the print will be. All right, thank you.
Commission. This year 22 of 2025,
Yes.
at page 63.
Hmm.
When they initially went to, second time went to Supreme Court, who was the petitioner there? He is the counsel here. Lordship may kindly see page 63.
Page
63.
of PIL number?
Page 63, annexure P15 of PIL 22. When he was there. Yeah. I'm a
No, no. Yes.
Daily list, item 6.
Six. 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 Oh, perfect. You're not so good.
फिर पिकअप लाइन मिला दिन का पता बात का टेकन ऑन मेरा 246 प्लस अगर somebody observe the particular demand
Yes, we had formulated a point for you to develop.
My lord, as per submission of my learned friend, that it was observed that the learned single judge had allowed the retribution only on the ground that the presiding officer, the commandant, has acted as interpreter. And as per 136, my friend held that rule 136, the commandant can interpret as interpreter. But my lord, if you go to the impugned judgment, my lord, of the learned single
Forget about impugned judgment. You can refer to section 124 and in its entirety, 124 of the BSF rules. Is it quoted there?
124 not put it, 120 section 126.
124 or 126, whichever is the section.
Yes,
two is the मतलब 124 अगर पेज 19 तो
What is the provision dwell capacity? Interpreter and.
134.
134
134.
134.
Yes.
134 2
No. Put the rules of one, not act. 134 2 of the rules.
of the rules.
The evidence will be taken.
Yes, even before the- 134, you can read it for your satisfaction and for our confirmation of the view.
134 2.
134, read entire 134.
134. When any evidence is given in a language which the court of the accused does not understand, that evidence shall be translated to the court or accused, as the case may be, in a language which he or he does understand. The court shall, for this purpose, either appoint an interpreter or shall itself take the oath or affirmation prescribed, or the interpreter For the interpreter.
At a summary security
Summary
force court.
security force, yeah.
So this was a summary security force
Summary
court.
security force, yeah.
You are a person from Manipur
Yeah.
and you never raised this objection that this interpretation is wrong. There should be an interpreter and I'm not understanding the language. This was not done before the court and before the appellate authority also. You did not raise this. Now, can that be a ground for the learned single judge to upset the findings of the summary force court? Especially when, I mean, other things have not to be gone into. The merits of the allegation we will not get into. The allegation was that you were found to be sleeping. Somebody woke you up. This was an ambush team. You were there on the Nagaland border. Somebody woke you up. You got up. Your weapon was scattered somewhere else. You cocked it and you also fired. And you took a plea that it was for self-defense. But then there was nothing. There was no onslaught. There was no threat. Nothing of the kind. You straight away fired because you were angry. Now, can that be a ground that you were not considered? And these grounds, these appreciation would not be within the domain of the decision making by a court. So the procedural formalities have to be seen whether it was followed. That was followed.
134.
आपने अपील में ये बात कही अपने
In the appeal, it is mentioned that interpreter, the dual charge was by the commandant. In the appeal, it is taken, the contention that the job of interpreter is by the commandant. It is one of the ground.
Appeal is allowed. The order of the learned the judgment passed by the learned single judge is set aside for set aside, and the decision of the summary force court is restored.
There was an observation of remand in the last occasions on this point.
The issue we are not at ease with the finding of the learned single judge only on that ground. 134, if 134 was relied upon, 134(2) should have been taken into consideration.
But 134(2), there is a provision of taking oath, my lord. That also not, my lord.
Where is that question raised by you? Where is that harm caused to you? Where is the prejudice that has been caused to you?
In the appeal, my lord, there is a contention in the appeal.
Item 7.
We are unhappy to do this. You get out of service, but then you are never reinstated. You was never reinstated, no?
No.
ये हमारे पास दे दो अभी Yes, Mr. Chaudhary. No, we had only asked you to find out. Is to superannuate.
Then also the director was from the blood union colleges and we are allowing to all the other coaching colleges.
Mr. Chaudhary, we found out this.
They've given me a copy. In that case, my lord, your lordships will hear it on merit and decide.
No, merits we have heard. Merits we have heard.
Just
You can re-argue that case. The difficulty is this: the learned single judge relies on the concept of lien on that permanent post. Now, this tenure post is supposed to be permanent. Now, the only ground which you can raise and you can defend the judgment of the learned single judge on the ground that you were allowed to stay beyond 5 years. So therefore, it was not a tenure post, it was kind of permanent post where you could not have been released. But that lien is something. I don't know how there
are certain facts, my lord.
No. There was some confusion with respect to application of few judgments over the concept of lien on that permanent tenure post. That is not the question here on which the learned single judge decided. The question is that you were on lien for 1 year. You joined on selection, on your, because that post was advertised, it was a tenure post of 5 years. So it is a permanent post. Only because of it being a tenure and therefore permanent post, you could take a lien. That lien was normally for 3 years, but it was specified that it will be for 1 year. They don't even fix the time limit. They say that if you're absorbed, it will be automatic termination. If you're not absorbed, you resign. Or if you don't want to come back, you resign. You did not resign. And sometimes later you did write for extension, which went unresponded. That is the only space where you can argue there is nothing.
Yeah, in fact, I'm absolutely with your lordship on that. Just two facts. What happened was, even before my 1 year period was over, I made an application for extension.
You made an application for
Extension of my lien. I did not get any response. They rather sent me a letter saying that you route your application through another channel, which I again did. That also went unresponded. Ultimately, my lord, after expiry of that 1 year, the government, it was in fact almost after several months, the government terminated the lien, against which I filed a writ petition. And there was an interim protection by the learned single parent, by virtue of which I continued and completed my 5 year. In the meantime, the other litigation that was initiated by me,
you're being released by the Gauhati investors.
that happened long after, because there was all along an interim protection from this honorable court. And that is how I continued in Gauhati University. Now, I am faced with a situation. Firstly, the advertisement says, expressly uses the word, if your lordship will just allow me to place the
How many
advertisement.
months do you have to go? For super?
I think next August time. Everything, my lord, perhaps luck was all along against me.
Luck was wrong. Luck was bad and you were not careful. And the place is full. Where do we place you? Even if we ask, even if we make a suggestion. In fact, that is what impelled us to ask Mr. Gogoi to find out.
I appreciate that. The very strange situation. The advertisement says.
Now, Mr. Indranil, look at this. You can't be accommodated in Gauhati Engineering College now. There is no sanction post. If there is no sanction post, you'd not like to go and work there. You'll not get your salary. Correct? We can't remove others. Time has passed. What can be done? I mean, we can't exceed our remit and say that please create a supernumerary post and place Mr. Indranil there. Can we do that?
And going by the entirety of the facts and also the spirit of Rule 12.
You should have been careful. If there was no extension, you should have come back if you did not want to stay there. It was a tenure post of 5 years. You knew it for certain. And there was no ambiguity in that tenure post of 5 years that it is a tenure of 5 years. And therefore permanent in the sense that post is vacant, post is sanctioned.
That is where the confusion arose.
No confusion. The law is very clear. It's the explanation, the fundamental rules number 9 to 13. They speak of tenure post as permanent post if it has a fixed tenure. Where is the confusion? All this is governed by the fundamental rules. So therefore, you were there only for 5 years. You should have taken a lien for 3 years with a further extension of 2 years, which is permissible. They were very careful. Your parent substantive employer, I mean, your substantive appointment was in the Gauhati Engineering College. The employer gave you a lien only for a year, knowing fully well that the post that you're going to occupy is of 5 years. So you were never absorbed. You could not have been absorbed. You can't even see that direction against Gauhati University. Because they took you in only on a post which had a tenure of 5 years.
That is why in none of the writ petitions perhaps this prayer was ever made for absorption. As the sequence of events would have it.
In fact, the safer option for you would have been to ask for your absorption there because you were continued. And the moment you say that this continuance was because of an interim order passed by the court, that chapter also gets closed. We have tried to explore all possibilities of accommodating you
That
for-
interim order has ultimately culminated in the judgment, which protects me.
that I think is questionable. We can't possibly help you, no matter how much we may try, because it's just an oversight. You probably did not understand, and I would not consider you, especially when you are so well educated. You're a professor of engineering. For your skills and for your knowledge, you were taken in that tenure post of 5 years as general. What is that? Academic council. Academic council is the 4th in ranking position in a university. The vice chancellor, pro vice chancellor, dean, and academic council chairman. You lost out.
Most of the time was used in the other department, not in the police.
Not in the
Not in the before 15 also. He was on the position to the assignment staff. He never last one.
We are not going to look.
That's the indicator.
This issue is different. We are going to
That's
limit.
the indicator. He was not the teaching line.
We are
Probably last.
We are absolutely in disagreement with the learned single judge with respect to his interpretation of your lead on the post in the university. That's not the question. Probably the single judge looks after it as some distinction has been tried to be made with respect to lien on that tenure post. Well, that question was not there, and that's unheard of.
But subject to correction, if your lordship just allows me to place
No,
that.
we have followed. This was an oversight.
Once a person gets in.
The place which gives you some space to argue is that your application for extension was not responded. It was
Never considered.
It was neither rejected nor allowed. So
And
therefore,
simultaneously, once they
therefore, they were highly justified in terminating the lease immediately after lien, immediately on expiry of 1 year.
it was not immediately. That is the other problem. After several months, and that termination got stayed by this honorable.
How can you question it legally? That is
But
sympathy.
I'm not on that one.
Sympathy is
Here is a situation. Gauhati University terminates, and this honorable court protects me, allows me to continue. Now, after that, that is why perhaps, my lord, if your lordship sees the earlier round of judgments, both the learned single judge.
there is no way out. What you want to keep-
In that case, my lord, your lordship will simply reverse the judgment and will perhaps take a chance on the 142.
Yes, 142 is the area where you can, and you can get. Because you have the qualification with you and your request was unresponded. Therefore, and there was an interim protection. But we sitting in appeal over a judgment
lordship,
226 we can't.
On that, my lord, I respectfully differ. 226 powers are wide enough for your lordships to.
Within the parameters of law, 142 power is something different. The appeal is allowed, the judgment includes the satisfaction.
Of life.
We tried to salvage the situation by asking for
I fully
the opportunity, but then
There are certain situations where all parties are helpless.
and Mr. Gogoi also tried his best.
Even also we
I-
in other engineering course also.
Oblige.
Item 14 for hearing.
In this case, we filed a very short affidavit summarizing everything, Lord.
I find it.
We filed it, I think, on 5th. Today is 9th. The affidavit filed by the Jal board will be most relevant.
412, 420.
Project wise, we have given the up to date status.
शुरू होता है 412, एक होता है 421. Like market. Six. Last. नहीं तो इन तक हम अंदर तक दोनों प्लेट मानी ऑफिस में बोलते हैं 412. And the point is, 421.
Page number, it will be Lordship, page 412.
One second.
Lordship.
Yes, we are satisfied. This is one and the other.
Under either 420. We have taken action against the defaulting contractors also. Everything
Let me
is
see.
Lord. Even this, the petitioner, Syriakhana Port, Jesdo Nagorik Sangha, that area also one old water system was there from 1970. That has also been replaced.
This,
The modern system.
this satisfies us. Now let's see what Mr. Fuken has.
Millard,
Yeah.
may I just hand over a key submission note, Millard? My colleague will hand over. Millard, I'll just confine my submissions just to two projects, Millard, East and West, Millard.
Central East and West.
East and West, Millard.
Now with respect to Southeast.
Southeast and West, Millard. Now, Millard, I'm just first two paragraphs. I've given the gist of the constitutional authorities, Millard, and also the provisions.
For what
And
purpose?
Millard, just for your lordship's satisfaction, that Millard, this is a important issue, Millard. Of course, your lordships have been monitoring this. Millard, if your lordship takes up their affidavit, they acknowledge that, Millard, in East, Millard, water has not reached any of the 67,000 Millard households in East, Southeast.
No. Why do you read something which is not there? It
So
says
in the
that-
affidavit, Millard, para 2, Roman 4, I'm referring to at page 417.
Reading that, it says that approximately 67,325 households are within the scope of this project, which has a capacity of 98 million liters daily. The project is likely to be completed in the year 2029.
My lord. Millard, this is a project that started in 2013, Millard.
Correct.
And therefore, all that I'm praying today, Millard, is that some directions may be issued so that, because none of the households have got water in this.
No.
Please.
We expect and we trust that when all this project has been undertaken and money has been spent, public money has been spent, all care is being taken to formalize all these projects for drinking potable water in all the areas of Gauhati. I don't think we need to We will not be monitoring it.
I'm not asking my lords to
In
monitor it.
case it
I'm
is
only
not
saying that
completed by the year 2029, come again, we will give you a hearing and we'll question them. We'll
Milord,
ask Mr. Saikia what has happened.
I'm only praying that something more than mere hope and trust, Milord, because this is water, Milord, one of the most
You
basic
suggest to
necessities
us
of life.
what guarantee do you want from the court or from the learned advocate general? Tell us.
No, Milord,
Guarantee in the
that I'm
political
praying.
meetings, I can give guarantee if I am a politician. But in the court, I cannot give guarantee.
Yeah, what Mr. Fu can tell us. We would
My
also be interested in knowing how to ensure, how to put it in an iron cast kind of an undertaking by the state. Tell us.
Milord, this is something that, Milord, I had brought to your lordship's attention in the context of Southwest. Your lordships will recall the numerous.
Let me tell you,
My lord,
this court is very happy that you flagged this. It
yes.
is because of this, flagging of the issue that the matter has come to this stage. Now if it is on the right path, so why do we stoke it further? Why do we just adopt the approach of overall guardian and the sentinel of everything? They are doing their work. If it doesn't happen, but wherever it is necessary, we find that they are lacking in their efforts. They are swindling the money. We will enter into the picture. But why now?
No, all that
Unless
I'm
you
saying, Milord,
dispute these.
I'm not trying to stoke any controversy or a conspiracy here, Milord. All that I'm trying to say is, considering the experience that the citizens have had in the past, Milord, these are projects which have been pending for more than 1.5 decades, Milord. And there is a judgment which I had annexed with my writ petition, Milord, of 1999, Gautam Uzir judgment. That judgment actually noted what the problem was. I'm not saying that work has not happened, Milord, but what is required, what is the need of the hour today, Milord, is something on war footing, Milord, because we are concerned with a very basic necessity, Milord, and this is not only, I mean, repeatedly courts have said that this is a extension of the right to life, Milord, and this is, Milord, certainly a
Very well.
Milord, and we are concerned with the right to live with
The order
dignity,
at 2.
my
We'll
lord.
dictate the order at 2.
My lord.
At 2 p.
My lord, may just consider the submissions, the written submissions, my lord. I've tried to give a summary because I don't want to take too much time, my lord, but at least the submissions I've tried to summarize, my lord.
Failure to provide most basic necessities. These are issues. Failure to
There's a
comply.
statute also of 2009, my lord, which really hasn't really seen the
There are
light.
3 or 4 contractors who have failed to deliver. That is why it got delayed. And they were got penalized. We have revoked all their security deposits. They are now running after us through arbitration cases. If the contractors fail to deliver, what the government can do?
We are not finding any space for us to question.
Because they want some observations so that they can play in the media. That is the whole concept.
My lord, I don't think, my lord, in connection with this case, my lord, there has been any, I don't know, my lord, I can't speak for my client, my lord, but I haven't
I have
dragged the
to
media
speak,
into
then this started sometime with the previous government. That is prior to 2016.
My lord, all that I'm saying is, my lord, that the lesson should be learned, and my lord, the history should not repeat itself here.
We are closing this CIS. We pass on.
Highly obliged, Lord.
Obliged, my lord.
How many packets more?
Item 19 and 20.
Yes. I'm seeing you after a long time, Mr. Hazarika. It took some time to identify that you're the same person. Yes. I've made a non-existent between what is satisfied and non-satisfied during the scheme of the act or the person. On that basis, we say that there is a technical whole matter actually revolves around the necessity informed upon good to properly defend.
after that. After the modify by certain, now that is called to generate whatever use and all. People are under section 30 of the Railway Act. If I understand, they are that's not the Railway Act. So this was only 9 specified command.
Give us 2 minutes, Mr. Azan. Now let's see that circular. It was 2.6 of the circular.
1-0.
Damage. It needs 109.
1-0.
No, circular.
That circular, railway code circular, 14 to 2011 circular. Yes, please read one.
Professional rate circular number 2010. Type of the following chart for the business of 9 notified for 1 will be seen other than white food trees other than tar and pulp, chemical manure, iron and steel.
That's what you're concerned with.
As classified in higher which stands from the 45 part 1 to consider will be taken as for the guidelines 92. These guidelines will be applicable for movement of water technique. Now, relevant for reading that because we are class of the rating of the legal concession. Yes, public charge for the movement of notified commodities in particular will be applicable. Will be levied on the basis of applicable plastic less 3%. Applicable plastic less 3% concession to contain plastic for the other specific. You have to consider plastic will be applicable. Consider plastic less 10% particular additional coming at the velocity 2.6. 1 41.
41.
Goods tariff number 41.
41
120.
121.
What is 126 1B?
1 yes, before that, we have page 121 per. This is important for everything.
Yes.
And below the general rules and chapters, the general classification about 5 The general classification of goods containing goods that is part 1 volume has the policy of the central government.
the authority of the Central. Of course, this is not the delegated. Then also come 127 people are to 101, rule 101. At 127. Yeah. Cooking of food like for etc. Good like for etc. is already in the area. To which to irrigation of the plant. Provided the stations are open for such traffic in accordance with the date used in the system. Specified in this tariff, subject to the variation published in the goods tariff and circular of the regulations. So the goods tariff will be subject to also variation in the circular which have been published. Then we'll now I'll take your article of page 120, 126, page 134. So let's see for false declaration. So I will one more. Page 107 at destination.
126.
One. Yes. Rule 106, page 124. Very good, right? Yes. And then for false. If on arrival at destination, the student is found that goods have been improperly dispatched under the lower rate than that currently application and which nearby activity, charges have doubled the cost to be at 300 rupees by the book flow as one of the relative income. 300 executive is 3 times the spending. Each of that is relevant. If in a consignment of packet, chargeable at different rates, a group of packages chargeable at particular rate is improperly dispatched and thereby a lower rate state. The charge is double the cost 300 XP because the subclass C above shall apply only to the group of packages in the consignment improperly dispatched and not to the entire consignment. Now, his case is that in the rate that was booked, his goods were not improperly dispatched by the consignor. The consignor in Roundkela had booked the entire rate, where he had, I'm told almost 50 out of 8 containers were improperly dispatched. His was on the balance sheet. Now, there came people a non-single judgment in the restriction law that because my goods were not improperly dispatched, I have asked this which should be reached. But then this rule, if it were applicable here, but this rule can be modified subsequently by the circular action of your law, asked for 14th of February 2011. Thereafter, the learned through the procedure on the basis that a distinction was made that this is a statutory rule because this is written as a rule under the circular and therefore administrative. But because it is a circular and therefore this will have to give way to the other. If this is binding, therefore this binding is
That's the basis for the judgment.
that can be. So then that is how one of the end result is found out that the restriction. Now therefore if there's a lot of some basis for lot point. So that is it. Come to the degree factor. Yes. Section 30 and consultation of it. The central government may from time to time power to take of it. The central government may from time to time by general of the special order fix for the carrying of passengers and goods, rates for the whole or any part of the region, and different rates may be fixed for different classes of goods and specify in the order the condition subject to the rates for the cost. The central government subject to by a light order fixed the rate for any of the class. Incidental to or connected with the tariff including demerit and forfeit for the whole or any part of the range and specify the order for conditions subject to the section. But you are not the power to very classify and also very. It will not happen. The central government shall have the power to classify or reclassify any commodity for the purpose of determining the rate to be charged for the carriage of the commodity. Increase or decrease the class rate commodity. So, in cases of the 9 particular commodity, it will modify kind of stuff. And what I showed you last week by the general tariff of page 151. It only says by the authority of the central government, it does not say under rule 1 and take up since you have the act yes, the logic to not rule section 190. But this is what learned judge after relying paragraph 70.
Section
198 and 199. Yes, I believe 190. General power to make use. Without prejudice to any power to make use contained elsewhere in the Act, the central government may make use generally to catch on the purposes of the Act. Rules to be laid before Parliament. Every rule made under this Act can be laid as soon as may be after it is made before House of Parliament, provided in session for a period of 30 days. It will be comprised in one session or two or more successive sessions before the expiry of the section following immediate session or the successive session. Both houses agree with any modification on the rule or both houses agree. The rule because even the rule can have next only modified form or the flow. As the case may be, so however, as any modification and which is the
But is at page 109, these haulage charge recoverable. I don't think it has the trappings of even rules. These are surplus. It can't go counter to the Railway Act. And it can't go counter to tariff 41.
What happens with central government?
We understand your argument. The general power to make rules that is delegated to the government, but with the caveat that it has to be laid before the Parliament. Before the Parliament. Yes. Now, the circular which has been relied upon, that is in complete derogation of the tariff rules. That's
precisely my case. Precisely the point. Yeah. The general tariff is not a delegated legislation. You're actually the company one thing to again. This is not a rule as in the statutory rule. It's a good statute. And these are contained in general rules. It says people are supposed to people nomenclature as well as an applicability that people are single just to hold it for. Good statute number 41, number 40, containing general rules for acceptance, carriage, and delivery of goods. The general classification of goods contains general rules for acceptance, carriage. Not the
What is that? Yes, yes, and we are not able to get the contours of your argument.
No, in page 103, they both act will clarify.
103.
Indian Railway Board Act.
Yes.
This delegate. So central government may by section 2 is the substantive section. Section 2 is government by an execution of official career. Industry Railway Board either applicable will all or any power of the function of the central government under the Indian Railway Act 89 at the bottom of the is also 89, because of the Act. Because with respect to all or any railway to the power of the officer referring to the particular the said act may rules for railway that respect as government. Any notice, determination, direction, the special opinion, approval of scientific given or signified on the part of the railway board for any of the purposes or in relation to any power of function which it may be invested by application under section 2 shall be sufficient and binding if writing signed by the railway board or by any other person authorized by the railway board to act on behalf of respect to the matter finished for authorization. The said railway board shall not in any case be found in respect of any other matter of course by cited in the matter of course. Over the page 1 and 4, I just lost it.
Yeah.
This is the notification of the Ministry of Railway, 31st of March 1990. In exercise of power conferred by section 2 of the Railway Board Act, the central government thereby invests the railway board with all powers and functions of the government of the Railway Act. The tariff setting power. So that is how they have tariff setting power. But you have 104.
1 second.
10. That's the delegate.
Yes,
So therefore, even the section 30 and 31 is about the content.
and one second. Yes,
So, what is the scheme? I show section 30 and 31 law. Yes, power of the government to notify alter delegate. Then the railway goes back. It authorizes the central government to delegate this power to you. Then there is a specific notification of delegation on the railway goes back, page 104, 31st of March 99, delegating the authority to the railway board, saying tariff. Then comes the goods tariff. Goods tariff they can buy or under the authority of the central government. And what does 101 of the goods tariff take? 104, you're not to come to the 120 from 120. 120. So that is important. 127. But so it's very important. That's the reason I showed 101. Because these are general. Booking of goods,
yes,
booking goods, livestock, etc. Booking in all various stations in India, to which through booking arrangements apply. Provided the stations are open for such traffic according to the rate, rules and conditions specified in this tariff, subject to the variation published in the goods tariff and circular of the railway concerned. So this is all issued by the railway board. Both of them. Whereas this one is subsequent because it cannot be that this is a dynamic. It cannot be that they are doing the 198. And if I may show, you are actually that the railway both acts with your rules of the 198 are technically mentioned. Because since this is a dynamic and ongoing and continuous activity, that is setting, that is resetting on a regular basis, daily basis, not on an hourly basis. That authority has to be the range.
what's the page number of that circular which has,
109.
based on which the container corporation has.
105.
109.
Yes.
And where are the rate circular number 30?
But you have there is a another one of 8th of November 2008.
No, let's see, where is the circular? Where is that circular? Circular number 30, which has been superseded by this circular.
As far as I understand, like, then the 8th of November. I just
8 of
other one. November 2003. 8th of November 2003, 290. That's the circular with penalty, because we are concerned only with the penalty part.
Who appears for the railways? And what do you have to say? No, but you are required to tell us. See, this circular at page 109.
Yes.
This circular, of course, it is by Government of India, Ministry of Railways, but that heading, that rubric does not make it a rule, does not make it a statutory rule, number one. Number two, at clause 4, it says this has been issued in consultation with the Traffic Transportation Directorate and concurrence of the Finance Directorate of the Ministry of Railways. Is the Joint Director Traffic Commercial Rates Railway Board has issued this. Now, whether this can run counter to these tariff 41, tariff 40 or tariff 41. No, this is the only issue. The rest we are not even concerned with. What was carried, what was booked, what was misrepresented. Now we will go to the misrepresentation later. That's a part which we will see later. But which is this circular? Is this a circular? Does this have the sanction of law as said? I mean, has it been placed before the parliament? If that is not placed before the parliament, then the general rules at page 127 that has been placed. That also is.
That also is not.
198 rule, I'm sorry, that what is that one? What is that one is not.
We would require the
The
railways to
does not make it a statutory. That is where I think also the confusion has gone.
Perhaps in terms of,
see 10.
1 second.
perhaps in terms of rule 199, whether it was laid before the parliament, that is the query logic is made.
It is not required because the delegation is to the railway board to do.
Delegation is all right, but then the delegation is subject to the conditions. The central government may by notification in the official gazette do so and so with the powers so and so. But the Railway Act says that for the rules to be operative, it has to be placed before the parliament.
But this is not a rule.
It's not a rule. Therefore, this
This is not a rule.
so therefore there cannot be strict insistence on this, and therefore, where has the learned second judge gone wrong in saying that it shall not apply for the entire rate? It shall apply only for the court has not also gone into the question whether it was a misdescription of the consignment. That is the issue. We are not finding anything from anywhere, no specific statement made whether this is the be all and end all for recovering the haulage.
No, my affidavit at the our affidavit at the because the learning thing is that release the credit.
And we have to keep everyone power is delegated to the railway. We have to implement it on the so if that means that this problem has been delegated to the railway. The best problem is the assessment.
That's really good. This is the
This is not. So basically, this is comparison between 1 to 8 of the 127. So balance delegated to 13. One be excellent. This is not excellent.
Become a sure that question of people of
1 second, sir. We are at it. Now, please come to page 103, Mr. Hazarika. So you have read section 2.
any notice determination directed equity. Expression of opinion, approval or sanction to be given justified on the part of the review court. Or any other purpose or intention to the power of the function. It may be justified by the jurisdiction under section 2 shall be sufficient and binding. It will likely find that the secretary to the railway court or by any other person authorized by the state railway board to act in the PR automatically authorized immediately. And the state railway board cannot in case be bound by the matter of unless by some type in the manner of. So this is delegated to the railway board. The secretary can then further subdelegate it to someone else, which is what will happen. The railway and what happens
Now look at this. I mean, you have to read section 2 carefully, 2 and 3. Don't,
oh, yeah, that's one to be
the difficulty is that these annexures are standalone annexures which do not explain the history. We do not know. Look at this. The central government may by notification in the official gazette invest the railway board either absolutely or subject to the conditions so and so. Now read number 3.
any notice, determination, direction, expedition, appointment.
Suppose the document at page 105 would fall in any one of these categories. Correct?
No, also on the page, that basically where is the
Any notice, determination, direction, requisition, appointment, expression of opinion, approval, sanction to be given or signified on the part of the railway board for any of the purposes of or in relation to any powers or functions with which it is invested by notification under section 2 shall be sufficient and binding if in writing signed by the secretary to the railway board or by any other person authorized by the said railway board to act in its behalf in respect of matters to which such authorization may relate. And the said railway board shall not in any case be bound in respect of any of the matters aforesaid unless by some writing signed in the manner thereof. Now come to next page. So in exercise of the powers conferred by section 2 of the Indian Railways Act, the central government hereby invests the railway board with all the powers and functions of the central government under section 30 and 31 of the Railways Act, which you had read to us. Power to classify commodities or to alter the rates. Correct? So far, so good. Now, this circular, where is the authorization? Where is this railway board secretary?
what they rely on the rule earlier.
Yes.
At 121 is also no such upper bracket. If I
No,
mean,
but
No, section
121 is without the delegation. It is by the central government itself.
under actually published by the Indian Railways for Conference. Indian Railway Conference. The heading. Is the Indian Railway Conference, not the Indian, it's not the railway board. But the point is, these are what happens is, as far as because I have taken instruction, these are all issued from time to time by various and then they are consolidated and put together. It has the authority of the central government. Because nothing says general classification of goods containing goods that part on volume 2 at the authority of the central government.
Maybe, but not by the central government. Two options. One is by the central government itself, or central government transfer its power under to railway board.
In this
Now,
case,
the first one which you are relying on is not by the railway board.
I'm not relying on, he's relying on that.
No.
It goes, this case also goes.
No, the railway board. And then this good traffic is by the central government.
No, actually, other than me as a public sector.
This is.
No. It is not placed under the. For the private and the public.
We are not able to appreciate the force of this circular, which is in supersession of the earlier circular number 30.
The subsequent circular, look at the extensions there are. Extensions have also happened. That was in 2014.
Now, what before the Leonard single judge, what was the stand of the railways?
The railway didn't have an affidavit there.
They did not file the railways. Now, how could it be decided then? How could it be decided then?
In fact, I have filed an application page 296 your lordship, 296, 298. I have made with the speaker government. It was not one. 296, my application 296 your lordship.
Let us have the report.
At 298, at 298, your lordship, the one paragraph there. That if the rate circular number 24 came to be issued in external power that provision, that is 31 and 34.
Mr. Arkady Chaudhary. Yes. You'll have to tell us. You see, merely bringing before us the general rules under the goods tariff number 41, Indian Railway Conference of the. Now we don't know because it's part of a document. It's a part of a compendium. Because if you come to page 127, chapter 1, the general rules, it just starts from page 101. Where do we find the recital with respect to the status of this goods tariff? No, but missing is something else. I mean, of course, it would have the authority of the railway board. It is under the concurrence. It has the authority of the central government. Central government has given power to a railway board. So therefore, these are direct rules. How the rubric is rather confusing. This also appears to be like a circular or something, goods tariff number 41, of course, with the authority of the government. But then this circular, we don't know what is it. And we don't even know it's a session of so and so, dated so and so, date money, is the particular. Now, Mr. Azari shall come to page 105. This is haulage charges recoverable from movement of containers in privately owned wagons. This we are not concerned with. 9 notified community. No, this is not by the general mandate for only. Where is the authorization, which is the statutory rule? You don't know. Which rule is in operation? It can't be a choice. And what is this superseded rate circular number 30 of 2010? That must be the earlier circular or the circular before that. The power of revocation, power of alteration is there. We don't understand this. Then we'll go by this rule. Tariff rule 41, which has been relied upon by this.
The 198 rule. That's a circular because that That what the logic says, the rule, it says that this is subject.
Yes, Mr. Chaudhary, what do you have to say?
Subsequent.
Lord,
Let the railways.
to be honest, my lord,
We have no option, but
to be honest, my lord, let us have the railways perspective, my lord, because end of the day, lordship will be determining the issue.
It took me some time to navigate.
Lord, prima facie, going by the description of the rules, learned single judge may not be wrong, but there are other aspects which I'm not opening my card, my lord. But before your lordship finally determines the issue, if the railways perspective is there, then it will be better.
you have heard Mr. Upmani Hazarika, learned senior advocate for the appellant. P.M. Chaudhary, learned senior advocate for respondent numbers.
One.
Respondent number one, and Mr. R.K.D. Chaudhary, Deputy Solicitor General for respondents number 2 and 3. This appeal has been preferred by Container Corporation of India, a public sector undertaking under the Ministry of Railways, whereby the judgment dated 14/11/2023, passed by a learned single judge of this court in WPC number 1974 of 2020 has been challenged. The appellant / Container Corporation operates container trains on Indian Railways under a concession agreement of 2007 with the Union of India, whereby it is bound by all the circulars and tariff orders issued by the Railway Board. The respondent number one, a manufacturer, had booked MS ingots from Rourkela to Gauhati with the corporation through an agency called Messrs. Reliable Sponge Private Limited. When the consignment reached Amingaon in Gauhati on 14/11/2024, the consignment was withheld by the appellant corporation, and a penalty was demanded from respondent number one on account of so-called misdeclaration of cargo, invoking clause 2.6 of the Railway Board circular dated 14/2/2011. The circular in question provides that in case of misdeclaration of goods in any container, haulage charges for the entire rake would be levied at 4 times the highest container class rate, in addition to the normal charges. This was questioned by respondent number one. The challenge mounted by respondent number one was basically on the demand by the appellant corporation, as also the validity of the circular dated 14/2/2011. The learned single judge held the circular in question to be in the nature of an executive instruction, which ran contrary to Rule 126(1)(b) of the Goods Tariff number 41, supposedly a central government set of rules. Based on the provisions contained in Rule 126, 1B of the Goods Tariff number 41, referred to above, the learned single judge modified or perhaps read down the stinging provision under 2.6 of the circular of 2011 and held that the penalty at 4 times the rate could be imposed only on the specific wrongly declared containers and not on the entire rate. Since the consignment of the respondent number 1 was found to be free of any misdeclaration, the penalty demand was quashed and it was directed that the goods be released. It is the case of the appellant. It was the case of the appellant before the learned single judge. That the railway board, on inquiry, intimated that the container corporation would be bound by the circular of the railways as per the concession agreement. And in that case, it would have to bear the burden of penalty. Mr. Hazarika, while canvassing his case, has submitted that the learned single judge was not justified in treating goods tariff number 41 as statutory rules under 198 of the Railways Act 1989, and in holding that the Railway Board circular issued under sections 30 cannot override it. Before the writ court, there was no affidavit filed on behalf of the railways with respect to the status of the aforenoted 2 circulars, namely the circular of 2011 referred to above and the goods tariff number 41 under the authority of the central government. Mr. R.K.D. Chaudhary, learned Deputy Solicitor General, Deputy Solicitor General, submits that the response affidavit clearly signifying the status of the aforenoted circular would be filed by the next date. Re-notify on after how many weeks? 3 weeks, 4 weeks? 4 weeks. Right. Mr. Chaudhary, you chose not to open the queries. Where has he disappeared?
Just a year's later.
How come he disappeared without our notice?
So good.
Oh, he said that he has not opened his cards. Was he keeping some point up his sleeve, which he will
Yes.
disclose on the next day?
Dear
If
points.
he has anything,
Yes, your lord, dearest
if
points.
he has anything, he must say it now. We will have
No.
it clarified.
No, your see, first of all, let them my
No, but why do you have to keep it under cover?
yes.
Now we can seek a clarification from the railways, no?
Yes, sir.
All.
Afterwards.
Item 21.
Yes, Mr. Talukdar. Yes. Now, we are not asking Mr. Pothakur to argue.
Well,
We have taken up it,
I understand.
taken it up on ourselves.
Well. Well, look, what I find,
No, what you find is something different. You may find many things. Now, we have shown to you on that day, if we remember correctly,
correct.
that there was a policy of the state to allow such persons who pass the test in the third attempt and reinstate them if they have been removed from service. It was pursuant to that the husband of the appellant was taken. Now, where does this civil rule come from?
Well, look, in fact, the policy, my lord,
That was irrelevant for Mr. Pothakur. Therefore, he did not appear in that petition. It was dismissed for non-prosecution. So be it. Suppose there were no civil rule. By virtue of this policy, would he have been reinstated or not?
well, look, in fact, there
Do
was,
you have any answer to this?
I
Just
am,
say that,
I'm,
otherwise-
I'm coming to that state, my lord.
Straight
There
away
was-
answer, otherwise
There
we
was,
have
there was no policy at all. Because what the document, my lord, which my learned friend is relying on, senior friend is relying on, is page 39. If I read the vernacular, my lord, the
Yes.
page 39, my lord. My lord, my lord Justice Chaudhary may follow me. It's in vernacular. May I read it, my lord? 6689. আলোকপুৰ উপৰোক্ত বিষয় সন্দৰ্ভত জনোৱা হল যে যিসকল বৃত্তিধাৰী শিক্ষক প্ৰশিক্ষণৰ পৰীক্ষা দি
You understand? You want to say that those who has completed the third part, they may be appointed through the procedure by following procedure.
Yes, what is
What is the procedure? Now, at that point of time, under the 1977 rules, there was no requirement of pre-training. It is only they were appointed as stipendiary teachers for 1 year or 2 year or until you send them to as per the rules for training. So there cannot be any fresh appointment with a condition that you have completed, because completion is condition to be fulfilled after appointment, not prior.
no, my lord,
So
what
you cannot give a different meaning to that.
Was any criteria set by the government?
no, in fact, my lord,
No,
here-
sure, because the English translation says at page 38, it is ordered that those stipendiary teachers who could not succeed in basic training course and removed from service and succeeded in third round are hereby given reappointment as per the criteria set by the government. Now,
this translation, my
if
lord,
you want to go against this,
this translation is not correct. Here, the vernacular,
as per the criteria set by the government, where is that criteria? Sure.
my lord, yes,
So what is the
Sarkari নীতি নিয়ম, my lord, what I understand, the recruitment rules holding the field. This was
Understand? That's why I'm asking you. The recruitment plan holding the field was 1977.
77 rules.
1977 rules says appointment then training. So there is no question of somebody passing the stipend and then going for a selection.
No, my lord, in fact, it provided, my lord, inviting application and selection process, all these things, my lord. Because what we find,
Where is that rule?
77 rule is with me, my lord.
72 read that. Where is that provision that somebody passes on the third time, there should be a fresh selection?
No, what I'm trying to say, my lord, this is what exactly what the learned single judge has held, that it was, my lord, divorced the procedure.
What is that procedure?
Procedure, my lord, inviting application.
Just a minute.
When did you superannuate, Mr. Pothakur? You retired in 2017. No. You retired when?
No, German guy.
Before retiring. in 2017. You were not paid your salary in 2013. 2013. 13 to 17 and thereafter pension.
In fact, the profit of my.
We are asking for a different. बोलिए 2 minutes. You have 2 minutes, Mr. Talbar.
No, no, only just I'm pointing out, this was the perspective.
We are directing for payment of the arrears of the salary till the time he had worked from 2013 to 2017. Plus you compute pension, give the family pension to the wife.
So as an officer of the court, when the lordship understand my predicament, I cannot concede. I also.
I'll record your name.
Yes.
We are giving all that benefit to him. We set aside the judgment of the learned single judge. We say that late Mr. Patil, late Mr. Patil was entitled for his salary from 2013 to 2002 for his till the time he superannuated, but unfortunately he died in
If I
2013.
correctly recollect.
So no back with no, not for the other people.
If I
13
correct,
17, it must be paid.
Yep.
The arrears would be received by the wife, by the appellant, and the pension shall be calculated, which shall
the
be.
last occasion, if I recollect, my learned senior friend has considered that the horse, my lord, the area part, my lord, he will be satisfied with the pension.
No.
That part.
Why should he? He can't.
That- The last
at
occasion,
least-
what your lordship.
No, at least the period he served you.
Served, that part.
That part.
Oh,
Yes,
that-
I'll leave it to you.
That part we are giving. Because see, had it been more for 20 years or something, you would not have paid. Perhaps Tarsen Singh would have come into play, but 4 years.
Yes.
Tarsen Singh says 3 years. 3 years. No, 4 years. We set aside, the single judgment is set aside, the appeal stands allowed. Everything is good.
Mr. Talukdar, give us a time limit for payment. Otherwise, beyond that, some interest.
And that also you cannot say, so we will fix our own date for within 4 months. Failing which interest at the rate of 9%.
Item 23.
And my learned friend did better today. But there is a Supreme Court judgment which may Gauhati. I have to go to.
Because after this judgment was delivered, the Supreme Court has taken up this matter and has decided this, how the pay is to be paid to the members of the consumer tribunals.
I will have to.
So that's.
Go through that and tell us. Incorporate it.
Give us a happy to answer.
Yes, madam.
It is Jaipal.
No, it's pay and allowances of the members of UP State Consumer. It's applicable to all of the entire country, madam.
Is that judgment?
That judgment, madam, is para 9, madam. In fact, the model rules paid was for payment of salaries, madam, to the members of the district consumer commission. But in the scale of deputy commissioner, deputy secretary.
Find out and tell us. You can hold it back. When? As prayed for on behalf of the appellant. We notify counsel to wait after 2 weeks.
But
21-7.